And then we are moving to the next topic, which is war on patents. And in that area, I would like to introduce Jonathan Caplan, where he's a partner and co-chair in Kramer, Levin, Naftalis firm. And also to invite Mr. Paul Andrea, where he's also a partner in this Kramer firm, where he's representing patents in different enforcement in US. And also the third person, which is going to be part of this panel, Dr. Eric Cole, where he is the co-founder and the CEO of Secure Anchor Consulting Company, with more than 30 years of network security experience. Dr. Eric has worked with a variety of clients ranging from Fortune 50 companies to top international banks to the CIA. With that, we have you here, Jonathan. The stage is for you. Thank you very much. Take us to the patent world.
Thank you, Dr. Mendel. And I want to say hello to everyone. And thank everyone for joining this panel discussion. As Dr. Mendel said, it's the war on patent, and we're going to talk about the largest patent judgment in U.S. history, which was obtained recently. And for the point of this conference, it was based on cyber security patents. So with that, I just want to introduce myself briefly, and I appreciate that from Dr. Mendel. But I am Jonathan Caplan. I'm a partner at Kramer, Levin. I sit in New York City, the co-chair of the IP group. And I want to introduce just again briefly the other panelists, Paul Andre, my co-chair of the IP group, and Paul sits in Silicon Valley, and our colleague, Dr. Cole. And as we're going to be talking about, Paul was one of the leading patent jury trial lawyers in the country, but most importantly for our discussion today, he led the trial team that got this large verdict based on cybersecurity patents. And Dr. Cole was our lead technical expert in the case. And as Dr. Mendel indicated, Dr. Cole is an expert in his own right. Over a span of a 30-plus year career, has worked for the U.S. Air Force, the CIA, the White House, and authored several books. But I want to get the discussion going and want to start by getting a little background for everyone, because this is not a legal discussion, but it's to kind of put the cybersecurity patents and litigation in context of the industry. And just put out a question, to Paul and to Eric, but just to get a sense, perhaps Paul, starting with you, kind of highlight some of kind of the current issues in cybersecurity patents and litigation in the U.S.
Thanks, Jonathan, and thanks for having us, for everyone joining. The past 10 years, the United States patent system has been under attack. This has been a result of a lot of frivolous lawsuits filed in the United States, and kind of the congressional action and court action has been throw a little bit of the baby out with the bathwater. So we now see a lot of challenges on patents, and this is the most difficult, one of the most difficult periods of patents I've ever had. There are 5 major challenges that we have now that's really evolved in the last 10 years. One is patent eligibility, and this is directly relevant to software patents and cybersecurity patents, and whether or not they are patent eligible. We had a case a few years ago for Finjan software that resulted in some clarity on this, and was actually helpful to us, but it is nonetheless, patent eligibility is a big issue. There's also been a new procedure introduced about 8 or 9 years ago called inter-parties review, where patents go back to the patent office and get re-reviewed. And this has been lovingly called the patent death squad. About 89% of all patents that go through here get killed. Efficient infringement, which is a term that was coined by the Wall Street Journal, is running rampant. This is where large corporate multinationals decided that it's more economically beneficial to take someone's technology and infringe the technology than it is to license it. This is running rampant in the society in the United States, and it's something that doesn't seem to be ending. Injunctive relief is mostly eliminated based on a Supreme Court case in the eBay case, And our Court of Appeals here that handles all patent cases is sharply divided. There's a split amongst the circuits, so there's a lot of uncertainty. Eric, I know you do a lot of work with a lot of different companies. You consult a lot of companies. Have you run into these type of issues? First of all, do you discuss patents with the companies you consult with? And do you guys deal with these issues we're talking about, the current state of patents?
Yeah, absolutely. And Paul, I echo what you said, where there was a big change 10, 11 years ago when I was CTO at McAfee. When new technology came out and they had patents, it was always acquire the company. It was always let the small companies do the innovation, let them build out a product. You pick the best one and you acquire the company. So this way you're rewarding the inventors. In the last 2 to 3 years, I saw a huge shift where these big companies say, hey, let's let these smaller companies come out, invent the technology. And then we have a team that's much bigger. We can throw much more money at it. So instead of spending $80 million to acquire the company, let's just spend $80 million to build competing technology and basically violate the patents and or steal the information. So there's definitely been a huge shift in how big tech looks at and deals with these smaller innovative companies.
So kind of picking up on that theme in terms of what's happened lately. So it sounds like it's harder today to kind of get and enforce cybersecurity patents. It may have been in the past, but what are some of the strategies or tactics that the companies can employ if they find that they've developed something important in the cyberspace and they want to protect it for themselves and also as a defense against people that are trying to encroach on their space?
Yeah, obviously this is an issue. We've got a single slide up here. This could be an entire day's discussion. This is it's an important topic as to, I think we lost my screen share here, maybe.
No, I still see it.
Oh, you see it? Okay, never mind. But it is the strategic considerations that we think about is you want to expect casualties. Every time you have a patent case in today's world, a lot of them are going to get killed. They're going to get killed through the IPR process, the ALICE process, or various other claim construction process, whatever it is. So you have to have a sufficient arsenal. You have to have a lot of patents. We recommend filing a lot of applications, getting different scopes of your inventions, cover your technology in ways you cannot imagine. The days of having a single patent family to cover your technology are over if you want to protect your technology. And you got to play the long game. It's a war of attrition to some degree. The bigger companies that will take your technology have more resources and can play the long game, and then have realistic expectations. A lot of companies think that if you have patents, you can keep people out of your space, and you can't. With efficient infringement today, as Eric talked about, it's just not something that is realistic. We have trial tactics as well. You have to understand the battlefield, make technology more relatable, and know who you're going after. Get their products, test them. Eric, I know you've done a lot of work with us in this patent infringement work, that kind of stuff. What kind of takeaways have you gotten from working in the patent litigation field that's different than what you do in your consulting role?
Yeah, first is, as you said, Paul, not only you want to have multiple patents, but you also want to have multiple claims within each of those patents. And the technologist needs to get very involved with the attorneys in building that to make sure you're really covering it from as many different angles as possible. And also when you're actually going into the litigation, one of the things we've been very successful working with your law firm is really doing that product testing. Most of the time it's source code review and looking at public-private documents, but testing products really gives you a great way to not only understand it, but it's something the jury can understand. When you're going in to a non-technical jury and you're trying to display source code and technical documents, it's not something they'll always understand. But if you can put up the graphical user interface, the product, and actually show how it works, how it functions, it's something that they can grasp and understand a lot better.
And that is an important point to make, is that in the United States, the vast majority of patent cases are tried before juries. It's not to a judge or technical expert. These are juries who have no technical background. Many of them are civil servants or school teachers or stay-at-home moms, whatever the case may be. So when you are taking this extremely complex technology, it's important technology, and trying to explain it to that audience, you got to know your audience. You have to understand how to explain that. That's the reason we hire experts like Dr. Cole to really help out with that type of explanation, and also the testing component. And also, what I'll also say, when it comes to protecting your technology, it's not enough just to think that you can file your patents and forget about them. As you continue to innovate, file new patents, continue that process. This is something that we all too often, smaller companies in particular, startup companies, will have a great idea. They'll file their first set of patents and they never follow up with that. This is something that it should be a continuing process to really get the full scope of what you're developing.
Yeah, Paul, just on that note, I just wanted to add that I think that it's a very important point kind of in the early stage of this process, because obviously before you can get a patent or enforce it, you have to apply. And this is not an issue of just quantity. It's about quantity and quality, but as Dr. Cole said, it's also diversity, that you just don't want to get multiple patents that look very similar to each other, or there's minor changes. Sometimes that's appropriate, but really what is strategically important early on is to get a variety, to think about your technology from a variety of different points of view, and how you'd protect it, how you defend it, and claim it in different ways. So when you get to the point where you have to enforce it, you have multiple different points of view that have to be considered and issues that have to be confronted. So that gives you a much better chance of making it through this whole process. So I just wanted to add that, because I think that's a very important point. So it sounds like, and I'll just put a general question out there before we turn to the case in particular. So, it sounds like cybersecurity companies should be thinking about their patents early on, so they can kind of start this process early and have the ability to protect themselves downstream. But how early should they be starting?
Eric, I'll let you take a first shot at that, because I know you work with a lot of startup companies and advise them. When do you give them that advice?
To me, it's do it immediately. Because, and Paul, I know you can cover more of the legal grounds, but my understanding is if you start talking about it, doing public presentations where people aren't under NDAs, you can actually make it more difficult or impossible to get those patents. So it's something, as soon as you have those ideas, the first thing you want to look at is prior art, understand what's in the space, because words matter. Sometimes going in and just adding a few clarifying words could differentiate you from existing technology. So understand what's out there, understand what makes you different. And I would recommend filing as soon as possible. And then Paul, I'll let you cover the legality of public disclosure and how that works.
Yeah, that is very important. One of the things that we stress a lot, and when we go to a lot of small companies, startup companies, when they're starting up, is when you start developing technology, it's a very exciting time in your life. It's a rush, and you want to tell the world about it, and it's good. You want to tell the world about it, but you need to protect it first. And because once you start telling the world about your technology, it's out there. It's no longer yours; it's the world's. So you've got to protect it. You got to file your applications early. If you make a disclosure prior to filing your application, and someone can run to the patent office with the exact same technology and file first, they get the invention, not you. It's a first to file law in the United States. So whoever gets to the patent office first gets the invention. So you got to be very, very careful. Even under NDA, be very, very careful. The second thing is that, understanding the difference between what I call incremental improvements of existing technology, which is somewhat exciting, but not that exciting, and the true innovative technology, the paradigm shift. Most of the true innovative companies have that paradigm shift, a whole different way of solving a problem. That's what gets people really on notice. If someone sees you doing something different, a whole new approach to solving a problem, they will copy it as fast as they can. So as soon as you make it public, they're all over it. The incremental improvements, people don't worry too much about those.
Well, that's a great segue to really get to not the guts of the presentation, because all these issues are important, but obviously, what we really want to get to is this recent case set the largest patent judgment in United States history. And so, Paul, just kind of, I'll start with you, is kind of give us a little setup and kind of what the case is about and how you got this, record result.
Sure. So our client's Centripetal Networks, based out of Virginia, and we had a case against Cisco Systems. Everyone knows who Cisco is, and this is on looking at cybersecurity at the packet layer, down at the network layer. And Centripetal started their company about 10 years ago, VC funded, one of these companies that did that paradigm shift. And they were smart enough that they filed patents early on before they made any public presentations. They were very diligent in getting their patents out. When they started developing their technology and they had a product out, they went into a non-disclosure agreement with Cisco to help maybe partner with them. And after over, I think it's like 14 months of discussion, the discussions end, and 6 months thereafter, Cisco Systems introduced a whole new product line in 2017 that looked remarkably like Centripetal's patented technology. So we started the lawsuits in 2018 and advanced from there. Originally, there were 10 patents from 7 different patent families that were filed in the original complaint. Only 5 of them went to trial. This is what I talked about earlier, but expect casualties. 5 of them got taken out by the death squad, the PTAB, Patent Trials and Appeal Board, and IPRs. So 5 of them went to trial, and we were able to prevail on 4 of the 5. And of the 4 of the 5 patents that were proved to be willfully infringed, we got a judgment of $1.9 billion in past damages and a future royalty that took the damages up to a range between $2.65 to $3.25 billion over the next 3 years. That judgment went final this March. It's going to be up on appeal, as you could imagine, but nonetheless, it was a very substantial victory. One of the key things about any of this is having a great invention story. Why did you come up with this new paradigm shifting technology? And Centripetal had a fantastic invention story, and we were able to tell that at trial. And just take one step back, this trial was done by Zoom. It was the first ever federal court case done by Zoom, because we were in the middle of the pandemic, and we went from a jury trial to a bench trial. So we have a judge. And that was it was the very first time it's ever been done. I've tried dozens of cases, and it's the first time I've ever had to do something by video. And it was a real trip, to say the least. But we got a good result, and we got the finding willful infringement. This is one of those instances that, like Eric talked about, and Eric testified to this at trial, where there was a non-disclosure agreement signed, and we were able to put evidence in that non-disclosure agreement was not honored. So there was a willful infringement story. Eric, maybe you can tell me about your personal experience, because I know he was our key infringement expert. 2 of the 4 patents, he was the infringement and also the willfulness story that helped us get the large number.
Yeah, so in this case, as Paul said, this was a bench trial with a judge who was very, very experienced, older, but not as familiar with the technology. So this goes back to making sure you really understand how the technology works so you can explain it at a very high level so non-technical people can understand how it works. And analogies are great ways of doing that, using testing of the product, diagrams, videos, and things along those lines. The other thing I would bring up too is make sure you understand the importance of documentation, that when you're having meetings or when you're disclosing things, to document what was covered and what was discussed, because that would be valuable evidence. On the other hand, remember that anytime you hit send, save, or post, that information lasts forever. So also be careful of your emails. If you start sending internal emails saying things that you shouldn't, that could also potentially be used against you. So email is evidence, and you want to make sure you're careful with what you document and what you don't document.
Yeah. If I can just kind of put something out to both Paul, to you, and to Eric, because I think probably in the audience, I'm expecting we have a number of engineers in the industry listening. Just talk a little bit about the role of engineers, technical experts, whether they're employees of the company or or engineers like Dr. Cole or experts in the field, kind of the role in overall and how, what they do in these cases?
So it's very important to be correct on the technology in these infringement cases. You've got to have it down and have the technology right, but in a way that's understandable. So we always have our inventors try to explain it. Now, anyone who's an engineer knows an engineer trying to explain something to a non-engineer is not always successful. So it's very important to work with the inventors to have them tell a story that's understandable and relatable to the audience, and it could be a judge or a jury. And then the role of outside experts in the United States, you hire outside experts to give opinions, and these people are not connected with the company. So the inventors may be experts in the field, but they're not considered experts in the case. They can just talk about factually what they did and how they did and why they did it, but they can't give any opinions as to whether or not another company is infringing. So we bring in outside experts like Dr. Cole, who can come in and then explain it in a way that a judge or jury will understand. In the centripetal case, it was a really fortuitous moment. It was right when there was a big hacking incident the night before, and it was made all the news, and the CBS television network had contacted Dr. Cole to do an interview that morning. So when the judge asked Dr. Cole about the hacking, he was actually discussing the news. So he actually could explain the cybersecurity at a broader context and how the centripetal technology could help protect against those type of hacks. It was actually just a very fortuitous moment.
That sounds like unbelievable timing. So let me ask you just about the trial itself. Was there a point in time, because you talked, well, you and Eric talked a lot about kind of having an invention story and making it understandable. Was there some point in the trial where you had a sense that the court was really understanding the point of view or the positions you were putting forward, and they weren't really going for the other side's arguments? Was there some point where that happened? And if you can just give us a little color on that, if there was something in particular that really kind of made that happen.
Yeah, one of the points was when actually Eric was on the stand, and we knew the judge was a big car guy. And Eric came up with a great analogy on the fly, by the way. Great job on that, where he brought up a car analogy and how it relates to cybersecurity. And at that point, you see it start clicking with the judge. We're putting it into relatable terms. And also, as Eric talked about, what was one of the case-changing moments was there was a lot of correspondence from Cisco that was not the most favorable towards them. And we actually give seminars to a lot of our clients about how not to create damaging documents. Anytime you write an email, assume it's going to be published on the New York Times. Don't say anything derogatory. Don't say anything that can be used against you. Eric, you may have another memory of when you thought things were going our way.
Yeah, I was just going to add on to that. To me, it's when the judge almost took over my cross and started asking me a lot more questions than the opposing counsel did. To me, when the judge starts engaging and asking questions, you know they're getting it and involved in the case.
Great. Well, I think actually, Kenny, you mentioned, I think it's a good time for us to move on to see if they have any questions from the audience. So Dr. Mendel.
Yes, we have questions from the audience. And the first question is the following. There are companies which have a policy that they are deleting the email history. Is that a good solution from your perspective?
It is. A document retention policy is very good. Email and document retention, I would get rid of everything I possibly can, especially internal emails. There's very little good that comes from that. External emails you can keep if it goes to third parties, because they will have those nonetheless. But internal emails would be a very good idea. There is a caveat. If you are in litigation or threat of litigation, you're not allowed to delete documents. So there is, anytime there's a threat of litigation or active litigation, you put a document hold. You cannot delete documents from that there on. But we have a pretty, when we advise clients, we advise them to have a pretty aggressive document retention policy.
Yeah, I think Dr. Cole made the point that anytime you send emails out, they're out there forever. So you really do want to think twice before you do it.
And the only thing I'll add on email policies is be careful of PSTs, because I know clients of ours that will say you can only retain emails for 30 days and they'll automatically delete them off the server. But if you have individuals that are having PSTs saving them locally and they did not delete them, as Paul said, when a litigation arises, that is now covered under that, and those have to be disclosed and cannot be deleted at that time.
Okay, so in that case, I think that to elaborate now, it's become very interesting, this topic, because the moment employees of such an organization keep email outside the system that they lead them, when there is a court decision, they need to reveal all the documentation, including those that have been stored specifically outside the system.
That's correct.
That's correct, yep.
Interesting. There is a question from the audience to Dr. Eric, please. Your direction that you said at the beginning, that big firms has moved from looking and acquiring startup companies with their innovation to more focusing on creating patents and protect the IP around that. Can you elaborate more around this, please?
Sure. So if you go back 10 or 12 years ago, it was really the technology that was important. So whether you did or didn't have patents really didn't directly come into whether a company would acquire you. If you had technology that worked, if you had customers and you had revenue, then that was of interest to them and they would acquire you. Now what we're seeing is they're looking at these companies saying, well, wait a second, if they don't have good protection of the IP, if they don't have really good, clean patents, then why should we acquire them when we can just basically take their technology, build our own, and try to build it better or different? So now all of a sudden, not only having patents, but making sure they're good, they're clean, as Paul said, that you have a huge portfolio with claims that really understand the prior art, have become a lot more important than it was 8 or 10 years ago if you're interested in building a company with ultimately an exit.
So they will have most likely a new challenge is to hire the talent that are available on those startup companies. And you know, to have today very high educated talents in the industry of cybersecurity and everything, engineering is becoming a worldwide issue. We are getting a lot of questions and requests in the academia to really create much more industry leaders, engineers, especially in the area of computer science and artificial intelligence, to be able that the market is really need them as much as possible. But with that, I want to tell you, thank you very much for this wonderful session. Most likely, Jonathan, in few hours, not few hours, in 10 hours, I will be in New York. So I will have the same background that you have on this. Well, I hope the weather is nice like in Israel.
You're in good shape this week. It's going to be a beautiful week here in the city.